Hello everyone, welcome back. I'm Awais Hassan Khan, Assistant Professor of Law at National Law University, Odisha. In our earlier video, we have discussed about marriage. I have introduced you what is marriage and how the idea of marriage has been changing in contemporary world. It was followed by discussion about marriage under Hindu law, the nature of marriage under Hindu law, followed by essential of a marriage under Hindu law. In this video, we would be discussing about marriage under Muslim law. Talking about marriage under Muslim law, the idea of a marriage under Muslim law is different from the idea of a marriage under Hindu law. In case of Muslim law, the marriage is considered as a civil contract between the two parties with a religious significance. Although you cannot call this civil contract as a pure civil contract in the same fashion as you buy commodities or goods in the market. Because in a marriage contract, although it is being called as a civil contract, but in this marriage contract, there are some emotional underpinnings. There are certain social underpinnings, and there are also certain religious significance. So you cannot call it pure civil contract, although it is true that a marriage under Muslim law is a civil contract. The Arabic equivalent of marriage under Muslim law is called as nikah, or the ceremony of nikah. And it is defined by Abdul Rahim as an institution partaking both the nature of ibadat, which means a devotional act, and muamalat, which means a worldly dealing. So it is both amalgamation of worldly affair in the form of civil contract and religious affair in the form of ibadat. And there's also a third aspect, which is emotional aspect. Because when you get married, you have emotional attachment with your spouse, but you don't have the same emotional attachment when you buy a commodity from a market. To understand nature of a Muslim marriage, there are two classic judgments. The first judgment is Abdul Qadir versus Salima, delivered by Justice Mahmood in 1886. He was a judge of Allahabad High Court. And he observed, I quote, marriage among Mohammedan is not a sacrament, but a pure civil contract. So how Justice Mahmood and Abdul Qadir versus Salima define the nature of a Muslim marriage, he defined it in terms of a pure civil contract. However, the judgment was not well taken and was subject to criticism because Justice Mahmood equated marriage with a pure civil contract, which is not a reality. Marriage has an emotional angle, marriage has a social angle, and marriage also has a religious angle. So you cannot call it as a pure civil contract in the same fashion as you enter into a contract for buying commodities in market. This judgment was altered in another case of Allahabad High Court, which is Anis Begum versus Muhammad Istifa. This judgment was delivered by Chief Justice Sir Shah Suleiman, who was the Chief Justice of Allahabad High Court, and he observed, marriage in Islam is not regarded as a mere civil contract, but as a religious sacrament too. So now how the two judgments differ, Justice Mahmood approach and Justice Shah Suleiman's approach. So in Justice Mahmood approach, he said it's a pure civil contract, but Justice Shah Suleiman said it's not mere civil contract because it is also having a religious angle in some fashion or the other. Although these religious factors are not mandatory, but these angles cannot be completely avoided. Coming to the essential of a Muslim marriage, before we understand essential of a Muslim marriage, we must appreciate that the marriage is a civil contract between the two parties, and it must be performed in the same fashion as you enter into a civil contract. So the first essential of a Muslim marriage is called as the ijab wa qabul in Arabic, which literally means as proposal and acceptance. And this proposal and acceptance, just like the way you have proposal and acceptance in a contract, must be through a free consent and must not be forced or coerced by anybody, including the parents of the party. So to whom to marry and when to marry is a decision which has to be taken by the parties to the marriage, means the bride and the bridegroom. The prospective bride and the bridegroom, they have to take the call. And this is the reason why ijab and qabul must be by the parties rather than somebody else, means the relationship of the party or the parents of the party. So this is the first essential, which is ijab wa qabul. Coming to the second essential is competency of the parties. Now regarding competency of the party, as per classic Muslim law, a party is competent to marriage the moment he attained the age of puberty, which in Arabic is called as baligh, or which is also used in Urdu as baligh, means adulthood. The moment you hit the puberty, you are fit enough to get married. But after Prohibition of Child Marriage Act 2006, even Muslim couple cannot marry unless and until the bride is 18 years of age and the bridegroom is 21 years of age. So for both Hindus and Muslims, or for anybody in India, the age is 18 for a girl and 21 for a man. This is the second essential of a Muslim marriage. Coming to the third essential talks about the absence of legal disability. So the parties who are going to get married into a nikah ceremony must not suffer from any legal disability. There could be 4 broad categories of legal disability which can invalidate the marriage. The first one is absolute disability, in which the parties cannot at all marry. For example, marriage in a direct blood relationship. So you cannot marry in a direct blood relationship. You cannot marry your son, daughter, or mother or father. This is a part of direct blood relationship. So if you marry in a direct blood relationship, it's an absolute disability and the marriage would be an invalid marriage or a void marriage. The second disability is relative disability. The relative disability, unlike absolute disability, will not completely make the marriage as a void, but it would be a disability which will impact the complete validity of a marriage. One of the examples of relative disability is the absence of witnesses, as per Sunni Hanafi law. Now, in case of a Sunni marriages, if you don't have witness to the marriage would be irregular. Unlike absolute disability, it would not be void. So that's the difference between absolute disability and relative disability. If you have absolute disability, your marriage is void, but you have relative disability, your marriage is just irregular, which can be subsequently regularized if you have a witness or you bring witnesses. So your marriage would not be completely void, it would be just irregular, although it will not also be completely valid. So this is a second kind of disability, which is relative disability. Third kind of disability is probated disability, in which certain kinds of marriages are completely prohibited. For example, polyandrous marriage. A woman having more than one husband is completely prohibited. This is a prohibited disability. Coming to the last disability, it is directory disability, which is in the form of a direction, which is desirable, which you may or may not do. For example, marrying a person suffering from life-threatening diseases. So it's only a directive disability. It is up to you. You may marry or you may not marry. So these are the 3 kinds of essential of a Muslim marriage. And with the fulfillment of these essentials, the marriage would be a valid marriage. Otherwise, it could be either irregular marriage, which could be subsequently regularized, or it would be a void marriage, which will have no validity in nature. That's all about marriage as per Muslim law. We would be now discussing about marriage under Special Marriage Act. Now, a Special Marriage Act, unlike the Hindu law or a Muslim law, is a secular legislation, or it is a state-given law to us. And it has not been inspired from religious scriptures or Vedic literature or Quranic law or the biblical laws. That's the one distinctive feature about the Special Marriage Act, that it's a state-given law to us and it's secular in nature. It is not inspired by our customary practice and religious practices. There's another thing about the Special Marriage Act. Under Special Marriage Act, interfaith marriages are permitted. Unlike in religious laws, unlike Muslim law or a Hindu law, interfaith marriages are not permitted. So under Hindu marriage, only 2 Hindus can marry. Under Muslim marriage, for most of the part, only 2 Muslims can marry, although Sunni men can marry a Kitabiya woman. A Muslim party can marry another Muslim party only. But under Special Marriage Act, interfaith marriages are also permitted. This Special Marriage Act was passed in 1954, and it provides for a special form of marriage, which is also called as a civil marriage. So it is not called as nikah or vivah, it is called as a civil marriage because it is performed through a civil procedure. And under Special Marriage Act, like the way we have discussed, marriage is purely a part of civil liberty question of an individual, which is beyond the constraint of religion or a caste. So both inter-caste marriages are also permitted in the Special Marriage Act, and interfaith marriages are also permitted under a Special Marriage Act, and there's no disability regarding the same. So this is about a Special Marriage Act. Coming to the essential of a Special Marriage Act, the essential of a special marriage is provided under Section 4, and these essentials must be fulfilled before you can have a valid marriage under a Special Marriage Act. The first essential is a monogamy. As we have already discussed, polygamous marriages are not permitted under a Special Marriage Act. So before you can marry, you should be either single or should be divorced, or your first spouse must be dead. in the lifetime of the first spouse, you cannot marry again without divorcing him or her. So this is the requirement of a monogamy, just the way we have discussed in case of Hindu Marriage Act under Section 5. The second essential is valid consent and the soundness of mind. The consent must be a free consent by the parties, again, not the parents, but the parties. And the consent must be given by a party who is of sound mind. So if you are insane, if you suffer from insanity, you're not fit to marry, and you cannot have a valid marriage even under Special Marriage Act. So soundness of mind is one of the essential requirements. The third essential is age, which is again common for all Hindu, Muslim, Christian, or atheist, which is 18 and 21. 18 for the girl and 21 for a boy. This is third essential. Coming to the fourth essential is the prohibited degree of relationship. Now, the prohibited degree of relationship is, there are certain relationships which are provided in the first schedule of the Act, Special Marriage Act, under Part 1 and 2. The whole list is given. In all those relationships, you cannot marry. So you should refer to Schedule 1 of the Act, and you will find out all the relationships. One thing you will find about these relationships is that these relationships are the direct blood relationship, as we have already discussed. Lineal descendant, ascendant, and the spouses, which is the part of prohibited degree, and you cannot marry in that prohibited degree. So these are the four essential of marriage under Special Marriage Act. Now, a Special Marriage Act, for most of the part, is procedural in nature, and before you can solemnize marriage under a Special Marriage Act, you must fulfill certain procedure. What are these procedures? I will tell you in the form of a steps, which is already also given in your slide. The first step is essential. So before you can marry under Special Marriage Act, you have to make sure that you fulfill the requirement of Section 4, which I have already told you. That is, you should have monogamous marriage, there should be a valid consent, you should be of sound mind, age requirement is 18 and 21, and you should not fall in the prohibited degree. Once you fulfill these essential, which is the part of the step 1, you can move to step 2, which is the notice. So under Section 5 of a Hindu Marriage Act, you can give notice to the marriage registrar of the district in which at least one of the party has been residing for last 30 days. And you can give the marriage notice to them saying that you intend to marry, and these are the parties who intend to marry under Special Marriage Act. Mentioning the name of both the spouses, both the prospective spouses in the marriage notice. This is the step 2. And this notice has to be submitted to marriage officer of the district concerned in which you are residing for at least 30 days. Next step is the step 3, which is about publication. So once you give the notice to marriage officer under Section 6 of the Special Marriage Act will publish this notice in a conspicuous place of the marriage registrar office, and he will also make an entry in the marriage notice book which he kept. Now the purpose of this notice and the purpose of this publication by the marriage officer is to invite objection to the marriage. If there is any objection by any party to a marriage, the same can be invited through the publication, and the same can be invited through the record. Next step is the step 4, which is objection to the marriage. As I told you in step 3, the marriage officer published the notice in a conspicuous place in his office. The purpose of this publication is to invite objection. So if anybody has an objection, he or she can submit the objection to the marriage officer under the step 4. Now this objection must be within the limit of Section 4. So any kind of an objection cannot be taken. Only those objections can be taken if it is in violation of Section 4 essential of a marriage. So you cannot take an objection that I was supposed to marry this girl or this boy and he's marrying somebody else. This is not the objection which you can possibly take. Or the parents cannot take an objection that these two, my son or my daughter has not taken my consent before going for a marriage. So this is not an objection. What is an objection? There are only 4 objections which you can take. That the marriage is not monogamous marriage, there is no valid consent, there is no age requirement 18, 21, and they fall in prohibited degree. Other than these 4 objections, you cannot have any other objection which is there in the mind of the party. Once these 4 steps are fulfilled, we have the final step, which is a step 5, which is a solemnization of the marriage. Now the solemnization of the marriage is done in the presence of the marriage officer to whom you have submitted the notice, along with 3 witnesses, as per the requirement of Section 11 and 12. And once these marriages solemnized, the marriage officer shall issue you a certificate under section 13, which is also called as a certificate of marriage. And once all these requirements are done, the parties are validly married under the provision of Special Marriage Act. So this is the procedure of a Special Marriage Act, which is both procedural in nature and which is also substantial in nature. And this is it about a Special Marriage Act, Muslim Marriage Act. And in the next video, we would be discussing about dissolution of marriage, the understanding of a dissolution of marriage as per Hindu law and Muslim law. Thank you so much.